Hello, Con Law class. Welcome to part 2 of the summary from week 7. Part 1 talked about executive power, and this part 2 talks about the Bill of Rights and the post-Civil War amendments. So remember that the first thing we talked about was the concept that the Bill of Rights does not apply directly to the states. And we saw this in the pre-Civil War case of Barron v. Mayor and City Council of Baltimore, involving a guy who had a claim relating to dredging that affected the harbor that he owned. And a clear holding in that case that the Bill of Rights only applies against the federal government, does not apply against state governments. We saw also how some of these issues played out in the infamous, terrible case of Dred Scott versus Sandford. So remember that in that case, Justice Taney held that enslaved blacks are not citizens under the Constitution. Talked about that sort of the general charters of freedom, the Declaration of Independence doesn't even really apply to blacks, and that the slave trade and fugitive slave clause in the Constitution shows directly that blacks are a separate class of persons and are not regarded as citizens, and further held the Missouri Compromise unconstitutional. So, this is a piece of constitutional history kind of showing what happens when the Bill of Rights are not applied to all citizens, and further, as we talked about, was one of the factors that leads to the instability that then ends up precipitating the Civil War. So after the Civil War, we saw that there were a number of amendments to the Constitution, which we call the Reconstruction Amendments, because it's in that era of kind of reconstructing, rebuilding the nation. 13th, 14th, and 15th Amendments adopted from 1865 through 1870. So remember, the 13th Amendment is the amendment that outlaws slavery or involuntary servitude, except for punishment of a crime, and we've talked a little bit in class about how that exception has played out through the Reconstruction era and seems to be playing out in some ways perhaps even today. We talked about the 14th Amendment, and we remember that the 14th Amendment, Section 1, has a number of different parts to it. We have the Citizenship Clause, we have the Privileges and Immunities Clause, which we spent a bit of time talking about in class. We had the Due Process Clause, which we spent a good amount of time talking about in class. And we had the Equal Protection Clause, which we have also spent a good amount of time talking about in class. So we also looked at other aspects of the 14th Amendment. Section 2, the apportionment provision, does away with the 3/5 clause in the original Constitution and penalizes but does not expressly prohibit disenfranchisement of freed slaves. Section 3 talks about office holding for persons who participated in the rebellion. Section 4 dealt with U.S. public debt and Confederate debt. Remember that it indicated that the Confederate debt would not be paid. And Section 5 is the enforcement power, which is something that we come to later in the semester. The 15th Amendment then deals with voting. And recall that Section 1 of the 15th Amendment says that voting shall not be abrogated based on race or color or previous condition of servitude. Section 2 is the enforcement provision, which again we come to later in the semester. So we saw then that the question arose early on about the extent to which these Reconstruction Amendments applied to give protections to citizens of a state against the actions of a state. And we see in the slaughterhouse cases, and recall that was a monopoly privilege granted to slaughterhouses, and a claim that this took away the ability of other people to compete and to work, that the Supreme Court said, no, these really are amendments that are designed to deal with slavery and involuntary servitude. They're not really designed to protect the privileges and immunities of citizens of the states with respect to actions of the states. They're designed to protect the privileges and immunities of the citizens of the United States And at that time, the court viewed those privileges and immunities as sort of relatively few, things like the ability to travel and so on, not internal state regulation. So we see kind of early on a question or a tension about how far these new amendments are going to extend. And recall the background is Barron v. Baltimore saying that the Bill of Rights does not apply to the states. But we see then the question begin to arise is, does or to what extent does the 14th Amendment incorporate provisions of the Bill of Rights and make them applicable as against the states? And remember that there was sort of a string of jurisprudence on this. The early Twining case said that the Bill of Rights are not incorporated into the 14th Amendment as such, just sort of a general background of what might be considered sort of a natural law of rights that are already existing. But then we saw Palco say, Justice Cardozo say that, well, there's a selective incorporation. The rights within the Bill of Rights that are considered fundamental rights will be incorporated into the 14th Amendment. We see Adamson, a dissent by Justice Black, kind of raising another perspective, which is total incorporation, the idea that the 14th Amendment is meant to incorporate all of the provisions of the Bill of Rights and apply them against the states. And what we see develop through the Warren Court is kind of selective incorporation, but that is applied in a less fact-specific way. So the selective incorporation in Palco is to say, we're going to look at this very specific set of facts in a given case and say it applies under these circumstances. The Warren Court doesn't quite do that. It still is saying we have to look at the particular right. It's not total incorporation, but we're going to look at it in a less fact-specific way. The question then is, once the court decides that a provision of the Bill of Rights is incorporated, what does that mean? Does it include all the details of all of the federal jurisprudence around that or not? And Wolf v. Colorado had said in 1949 that only the core of the right is incorporated, but Mapp v. Ohio in 1961 reverses Wolf and says, once it's incorporated, every detail of the guarantee is incorporated as against the states. Now, we talked a little bit about specifically which rights within the Bill of Rights have been incorporated. And as we discussed, really on the criminal side, all of the guarantees, all of the criminal guarantees within the Bill of Rights, things like the right against self-incrimination, the right to have witnesses presented against you, the rights in the Fourth Amendment about search and seizure, all of those things, except for provisions about grand jury indictments and possibly the excessive bail provision of the Eighth Amendment. And we saw on the civil side all of the First Amendment guarantees, the Second Amendment right to bear arms, which we'll talk about, which we have talked about and I'll just review in a moment, the Fifth Amendment takings clause, and then a few things we have seen have not been incorporated. The Third Amendment about quartering troops, the Seventh Amendment right to a jury trial in civil suits at common law, and the Eighth Amendment protection against excessive fines. And some of this is sort of historical accident. Some of this is some distinction between civil and criminal. So we focused then in this week on the Second Amendment right to bear arms. We looked at the D.C. versus Heller case. Recall that the opinion was written by Justice Scalia and was supported by the conservative bloc of the court. And the question in this case was, what is the meaning of the Second Amendment? And remember that Justice Scalia said that the Second Amendment, which I have up on the screen here, is broken into a prefatory clause and an operative clause. The debate was, and really, sort of continues to be, although Heller has settled it at least for now, whether that prefatory clause about the militia limits the scope of the Second Amendment. And Justice Scalia said it does not. It's kind of historical background. But the operative clause is not limited by the role of militias. And so the individual right to bear arms is protected by the Second Amendment. And we note that in Heller it's not an incorporation issue, but this is a basic right that we would anticipate would be incorporated against the states. Now, there are some qualifications in D.C. versus Heller. The majority says it doesn't protect against sort of atypical kinds of weapons that are not held by law-abiding citizens for lawful purposes, like a short-barreled shotgun, and further suggests that kind of reasonable restrictions for the mentally ill or sensitive places like schools or other things along those lines could still be upheld, even though the right is an individual right. So this is the review for this section, and we'll move on to the next week.